Supposing a select committee is to be formed and a person to be nominated. Who decides that? If 40 members of the House will say, no, because we are 40, we nominate this person? No. The whip will tell the speaker that this is our nominee on this select committee or this joint committee or the standing committee. So this gives him wide power of patronage, which comes handy in keeping with party members amenable to his influence. It is thus clear from a reading of the aforesaid that the whip forms an important link, an umbilical cord between the political party and the legislators. The whip enforces the directions of the political party. Then, my lords, there is a discussion about how the term political party actually was not there in the constitution earlier, or not constitution, even otherwise was not there in a statute. Then was 29A of the representation. I don't have to go through the history, we are short of time, and I don't want to take time unnecessarily. My learned friend can, if he wishes to deal with some of this. Then kindly come to, there is a judgment of this court in 2018, volume 9, SCC, 2018-9 SEC, page 100. This is Sailesh Manubai Parmar versus Election Commission of India. Yes. Mullahs, in this case, mullahs, they wanted to introduce nota option in the Rajya Sabha elections, mullahs, for elections to the Rajya Sabha. Mullahs, in that context, mullahs, at page 116, the judgment starts at 100. I just read one paragraph, paragraph 19 at page 116. Page 116, paragraph 19.
Yes, we all are here.
Yes, no, I just read it. The aforesaid passages throw immense light on the distinction between direct and indirect elections, and especially on the concept of indirect election, which encompasses proportional representation. There is voting by open ballot, and it has been so introduced to sustain the foundational values of party discipline and to avoid any kind of cross-voting, thereby ensuring purity in the election process. They have been treated as core values of democracy and fair election. It is worth to note that in a voting for members of the Council of States, the nature of voting by an elector is a grave concern. It is because if in such an election, there is a party whip, and the elector is bound to obey the command of the party. The party discipline in this kind of election is of extreme significance. For that is the fulcrum of the existence of political parties. It is essential in a parliamentary democracy. The thought of cross-voting and corruption is obnoxious in such a voting. In this context, we may refer with profit to the then para, mullahs, 22 at page 118. 23 actually. No, let's deal with 20. So we have to cut out this thing, time is short. 23 at page 118. If I may read, mullahs. In a democracy, the purity of election is categorically imperative. The democratic body politics, as has been held in Manoj Narula, stipulates that the quintessential idea of democracy is abhorrent to corruption and law's emphasis on prevalence of genuine orderliness, positive propriety, dedicated discipline, and sanguine sanctity by constant affirmance of constitutional morality, which is the pillar stone of good governance. The purity of democracy does not withstand anything that has the potential to create an incurable chasm in the backbone of a democratic setup. The law is meant to eradicate the same. When one analyzes the exercise of choice nota in the voting process of the Council of States, where open ballot is permissible and secrecy of voting has no room, and further where this discipline of the political parties matters, it is clear that such choice will have a negative impact. That's all, mullahs, that I wish to state. The mullahs coming back to. Mullahs, I skip that. And I come, mullahs, now to. I have dealt with the facts now, mullahs. And I don't want to take too much time now. Then, mullahs, now I come to the governor's decision.
Chapter 9.
Yes, mullahs, chapter 9. I'm not going to intra-party decisions, mullahs. I'll just save time. Come to chapter 9. Now, mullahs, this is, as I said, an issue that has arisen for the first time. A member of the BJP along with...
where does chapter 9 begin? Page 100?
Sorry, page 100.
Page 100.
I'm sorry. I should have mentioned that.
Yes.
Well, it's 235. It is respectfully submitted that the exercise...
it's the 28th of June decision of the governor. Decision of the governor, which...
to invite Shinde, Malas.
That's right, yeah. 28th of June.
30th.
30th.
28th is our trust vote. We do not, Malas, go to the trust vote.
30th.
30th, Malas, he is sworn in.
Correct.
Correct. Now, Malas, your Lordship knows that under the Constitution, there are areas where the governor has discretionary powers, subject to 3 exceptions which are given in Nabam Rebia. This is an area when, in the beginning, Malas, there's an election that takes place. Who is to form the government? There is enough discretion with the governor. He will see as to whether there's a pre-poll alliance, and if the pre-poll alliance has majority, he'll call the leader in the normally. I mean, there are exceptions. There's a if he doesn't get a pre-poll alliance majority, he'll call a post-poll alliance. And if not, he'll otherwise see if a majority can be cobbled up by a leader who has the confidence of the House, who may have the confidence of the House. That discretion is always with him, Now, we are talking of the discretion of a governor post the formation of a government. That's the first issue. So, post the formation of an elected government, if 10 people go to the governor, what is his discretion in the matter? Because the governor has to ascertain, one, that look, these people along with others, the leadership that I will administer the oath to will have the confidence of the House. That's one criteria on the basis of which he will swear in him. 2, he will ask the question, which party do you belong to? He's naturally have to ask. I am sure he will know that before even he asks that question. So he knows, that the Shiv Sena is not before him. On the 30th, he knows Shiv Sena is not before him. So what is his discretion in administering the oath of office to Eknath Shinde? Except the fact that all the 39 rebels will support, or the BJP along with the 39 rebels will oust the government and will support the new chief minister. He also knows, there is a disqualification petition pending. So your lordships will have to decide for the first time in situations of this nature when there's already an elected government in place and there is a taint, alleged taint of a certain set of members pursuant to the fact that disqualification proceedings are pending, whether the governor can exercise discretion in a manner which will topple an elected government, not await the outcome of the disqualification proceedings. The governor could have done 2 things. Could have said, I know for a fact that there is a disqualification notice against you all, or against 16 of you. You who want me to administer an oath of office to want to be the chief minister. The court has given you time till the 12th of July. Please first file your reply on the 12th of July, see the outcome of those proceedings, and if there is no taint as far as your membership is concerned, I will administer the oath of office to you. That, I think, is a constitutionally moral path that the governor ought to have adopted. Because institutional morality demands that he follows that path. The Constitution, in fact, persuades him to follow that path. Why? Because there's an elected government in place, of which he was a member. He himself. Eknath Shinde was a member. So why would a governor administer oath except that he himself knows that the elected government will be toppled? That's a very serious matter according to me, Maharaj. You looked at the Sarkaria Commission report, Maharaj, your lordships will find no such eventuality, Maharaj, considered. The governor, which...
Eventualities are to be considered on experience.
That's true. That's true. Because ultimately, democracy only thrives when institutions uphold the sanctity of the Constitution. And quite frankly, Malas, and this is again my personal opinion, no court, no institution should balk from that, should withhold its hands from that. Because ultimately it's the message sent by court, by institutions, that we are above the vicissitudes of fortune that come with politics. That's the only way, Malas, to gain respect within the public and to uphold the values for which our forefathers gave us this republic. But unfortunately, that's not to be. So, Malas, here there is a big conundrum, very big conundrum. So first, Malas, the 27th order, the 29th order, then the governor. Even the governor could have stopped it. When he even chose not to stop it. So your lordships will have to evolve some principle in the context of, because this, if Nabam Malas is not overruled, this will happen time and again. And the governor will play, I'm sorry to say, Malas, I have seen the governor, it happened in Arunachal. Dead ball. And we have seen, Malas, and I mean no disrespect to the institution of the governor, we have seen governors performing a more proactive role as institutional heads within the state, which has created disturbances within the polity. So, therefore, how your lordships will evolve a principle to ensure that constitutional morality is upheld is something that I leave it to your lordships. I cannot give an answer. I can only say in the facts and circumstances of this case, the governor should not have administered the oath of office to Eknath Shinde.